Welcome to Command and Control, a podcast series about military command and the control measures used to orchestrate combat engagements and wars. In this episode, we're talking to Brigadier General Lisa Ferris about the role and realities of the legal advisor in command and control decision making. The show is sponsored by Systematic.
At Systematic, we make the coordination of fires simple by unifying your operational and fires missions plans into one C4 ISR management platform. The Sit-Aware Fire Support module increases your responsiveness by reducing the time between target identification and fire's response, while ensuring full collaboration between all elements involved in the operation.
That military actions are governed by both behaviours, policy and law will not be a shock to this audience, or at least they shouldn't be. Yet there is considerably more emphasis placed on rules of engagement, release criteria and national interpretations of self-defence in the training and education of military personnel than in the legal principles that sit behind them. Those principles were created by fighters who had experienced the cauldron of combat across millennia and determined that there were some basic ideas about the conduct of war, the treatment of prisoners and civilians and animals that needed to be codified. Whether the Code of the Hummurari in 1750 BCE, how guidance was drawn from the Book of Deuteronomy, the ethics of 7th century caliph Abu Bakr, or the writings of Augustine of Hippo, the laws of war had a huge history associated to them. Today, governed still by international law above all else, commanders cannot get away from the complexities of the law on operations, and, with increasing scrutiny on military action after the fact, the role of the legal advisor in a headquarters has rarely been more important. But the Legad occupies an unusual and difficult position, holding the moral, ethical and legal boundaries in focus in the midst of hard, perhaps even existential fighting requires tenacity, honesty and considerable courage. In New Zealand, legads in the military sit outside of the command chain. A commander does not get to write the report on their legad. They cannot influence decisions, advice and the careers of their legal officers. This provides a legad with permissions and freedoms that others of similar rank do not have in headquarters, and that's importance. The independence of the legad, especially in rank-conscious hierarchical organisations like the military, is vital in ensuring that military forces do not cross the line between legal and illegal action. As a discussion on what's lawful in war and what is not becomes increasingly passionate across our forces, I asked Brigadier General Lisa Ferris from the New Zealand Defence Force to talk to us about the role of the legad in command and control. Lisa is currently working as a defence attaché to the UK right now, but in her last job, she was head of New Zealand Defence Force's legal services team. Here's our conversation. So, Lisa, what does a legad do in a headquarters?
I can speak obviously from the view of the New Zealand Defence Force legal advisor. It would almost be like, what does a legad not do in a headquarters? But no, to be serious, we sort of look at ourselves as a specialist general practice lawyer in New Zealand. So we provide advice to commanders on a whole range of subject matter, including operational legal advice, advice on law of armed conflict, advice on international law such as treaties and arrangements and agreements, advice on disciplinary issues, including all the way up to court-martial offences. We also do house and grounds matters such as real estate, purchasing and selling of items. What is it there that we do in terms of a legal advisor?
So is it, and I've seen lots of legal advisors operate in headquarters, and their relationship with the commander is, that personality to personality relationship matters so much in terms of almost how much the commander's willing to accept, right? But in many ways, you're expected by the rest of the headquarters to be the sort of conscience.
Yeah, I would agree with that. And I think personal relationships do matter, but I think they matter across the board in all military units. You cannot have an effective unit unless you have really good working relationships in the command chain. I think with New Zealand Defence Force, we have a slightly unique view. The legad is outside the command chain, so we are not actually within the regular command chain. So when I was Director of Defence Legal Services, I commanded all the lawyers through. So the C2 is separated, which gives a unique role for a legad in a headquarters to be able to provide that free and frank advice without it necessarily harming their career prospects. And I think it removes that risk of a commander being able to influence, and I'm not necessarily saying this would happen, but it just takes out that risk that they could influence a legad's career.
But it's not just that, it's about how the legad gives advice. I've always been surprised how ballsy legads are in their dealings with commanders. I mean, because we're in such a hierarchical structure in the military, I remember being in a land headquarters and the commander was God, right? And we weren't aware of anything that happened outside that mattered. And the G3, G5 team were putting things in. If it was rejected, it wasn't the commander's. Everything was answering to him. No one really went against him. His deputy sort of might have suggested some stuff. His chief of staff might have, tried to go in. The international liaison officers were pretty good at, nudging. But the legad was, frankly, really blunt. I mean, it was brave. It was courageous, some of this stuff. And you would have thought it was career ending, right? I mean, so that separation of powers is quite a powerful thing to undergo, right?
Absolutely. And I agree. One of the foundational requirements of a legal advisor is to speak truth to power, right? Is to tell commanders often news or advice they don't want to hear. And I think we actually recruit for that. The ability for lawyers or service people in the military that want to do the legal advisor role, that they have to be able to stand up to commanders, no matter how forceful or dynamic or confrontational the engagement may be.
The moral and ethical parts of this are often difficult because they are in the character, the intent of international law, but not necessarily the codification of it, right?
In my opinion, the law of armed conflict is the bedrock of how we operate as a professional armed force. For a legal advisor, absolutely there is an ethical dimension to the role they play. They're not necessarily ethicists, though, and I know that some other militaries have employed ethical advisors specifically, such as the Australians, I think, also look at ethics as slightly different to the law. But I would say that as a legal advisor, you have both professional and ethical obligations to put lawful, appropriate advice to commander. So it is an all-encompassing role.
And it's a role that comes in at various parts of headquarters, right? And in peacetime, lots of Western militaries only employ a legad at sort of the divisional level, maybe the brigade. But when deployed, brigades definitely get them. And sometimes they go below that to battle group commanders or a task group organisation. They tend to permeate much lower down. But before that, commanders have had very little exposure to legads and are expected to get on and understand their own interpretations of it, right? There is this really difficult moment at which you say, I need a legad advice on this, and I don't. Most often, commanding officers, for example, will come when it's a court-martial, a disciplinary offence, right? But apart from that, they'll conduct operations almost entirely without a legad.
I think this is where scale might come into it a little bit. I would say that in New Zealand, at least, most commanders have grown up with legads hand in glove with their units. And we had lawyers at every base and camp throughout New Zealand and advising on commanders down to sort of unit level, effectively, on a whole range of matters. They're integral, in my view, to all units. And in fact, I had one former Chief of Defence Force say that he would not go anywhere without his lawyer in terms of any matter nearly. And I think in New Zealand, so for example, I deployed on a frigate to the Arabian Gulf, and that's much smaller than a divisional level, to advise the captain of that ship on maritime security law matters. And I also deployed to Afghanistan at unit level.
Have you found that, I mean, it's an amazing thing. I've deployed on so many ships in the Gulf and none of them had a legad on. I'm deeply impressed, but lots of commanding officers, in my experience, and warfare officers and commanders in naval perspective, but lots of people in the military tend to think as law as a restrictor, right, as a boundary, and therefore the legad becomes the blocker to execution of operations. And I'm just not sure that's the case. Have you found that exposure to legads changes that view?
Yeah, I think over time, in the 20 plus years that I've been serving and when I was a legal advisor, and early on in my career, we were seen as the barrier to getting things done, but I think it's a myth, right? The legal framework is what it is. It is the boundary of what is legally permissible for militaries to do. But I view, and I like to think that commanders are increasingly viewing a lawyer as an enabler. I am here. I want you to achieve your task or objective. We are all after the same goal, to have a successful operation, how can I get to green? How can I assist the commander get to green in a lawful manner? That is my whole reason for being. And to reduce risk as well to the commander so that they don't fall afoul of the law. So basically my whole goal is to protect the commander and achieve the mission.
It's interesting as well that lots of people, particularly early in their career, are taught the basics of, law of armed conflict, Geneva Conventions, IHL. They learn about these things, which then they're sort of shocked as like the boundaries of operations. And therefore it stops me doing this, that, and the other. And then there is very little education on that beyond detailed study of rules of engagement. But there is sort of nothing beyond that until you get to a sort of staff course level. Even then, the coverage of the legal aspects is not great. In professional military education terms, do you think it's satisfactory? I mean, we've come up with a slew of recent cases internationally where people have run afoul of IHL and national laws, but IHL mainly. Is this something to do with our failure in military education in the West?
I mean, I would always love to see more law taught throughout the military. It's a bias of mine. But I think what we've also seen, and this is a personal reflection, is we've sort of gone through the counter-terrorism era where there was such a heavy reliance on rules of engagement, almost to the exclusion of the law in which they were based on. And now we're sort of emerging into this era of sort of great powers competition. Rules of engagement are almost, I'd say, hopefully naturally going back into their place as a subservient set of rules to the law. And I think the focus more properly should be on the law of armed conflict as the framework in which we operate. And a lot of people sort of forget that rules of engagement are policy setting. They're orders, they're policy settings, they're not law. They may have some elements of the law in them and they may reflect some of the legal obligations, but they sit underneath, a lot of the time, the law of armed conflict. You may have a rules of engagement package that may expand to the full extent of the law of armed conflict, usually not. Usually they do restrict you some more, but I think there has been an over-reliance on teaching rules of engagement to the exclusion of the legal framework.
And it also feels like there's been a prioritisation of national law over IHL. And the people seem to conveniently forget that, national law, again, is subservient to international law. Even where you think it's a legal order nationally, if it's not under IHL, then you're still liable, right?
So I think obviously different countries have different interpretations or implementation and how they treat international law. From New Zealand's perspective, our national law must comply and be complementary to international law. So that's the New Zealand position. So I think sometimes there is that conflation between national laws and international law and law of armed conflict, and also between peacetime laws around self-defence and use of force and law of armed conflict rules, which are two separate things that often get mixed up together.
And much of international law, since we're on the topic, is based on millennia old agreements, established processes, treaties written in the 6th century, the Book of Deuteronomy, feature. It's incredible that it goes back, but it has this enormous precedent that go back over sort of what we regard as civilizing societies. And all of that is captured within IHL and Geneva Conventions, right?
So, yeah, as you say, you go back to the Hummurari Code, you've got a whole range of sources of where we've drawn the law from. And there's two forms of law. There's customary international law, which is that law which has evolved over time through practice and implementation. There's also codified law. So the Geneva Conventions, the classic example, virtually universally agreed set of rules and regulations that govern conflict, that is the sort of product of that eons of practice and armed conflict. And I think the fact that all nations of the world came together and agreed those, and to be fair, some of it has aged, they were written at certain points in time, but the principles still survive. And I think that's what's key.
And I'm always slightly shocked when you talk to people about international law, that there's a view, particularly in the last 10 years, that this was all written by lawyers. Nothing could be further from the truth. I mean, all of these, the principles, the tenets, the character of international law was written by people who'd walked through big battles, who'd seen the cauldron, the face of death, and had walked out the other side. and said, we need to govern this in some way to do it in a slightly better fashion, right?
Yeah.
But there's no acknowledgement of that. It's put solely at the blame of lawyers, right?
True, yeah. I mean, yeah, Henry Dunant, right? Like Battle of Solferino, 1863, I think, from memory. Yeah, he literally, from a humanitarian point of view, witnessed the carnage of a battlefield and said there must be a better way to try and protect civilians. So the genesis has not been from the legal officer or the legad, but from the humanitarians amongst us, which is a valuable and appropriate, I think, genesis of our statutes. But we are responsible for interpreting those statutes. And I think that's where the legads come in. And we have to own that as well. That's our role and responsibility and our weight that we have to carry, I guess.
So I really get this in a national perspective, and it strikes me that New Zealand are far ahead of others in terms of just exposure to legads, let alone embedding legads at much lower levels than other states. But when you're working in coalitions, when you're working in an alliance structure, you will have differing national interpretations, right? And for a commander, those can be opportunities, right? So, for example, let's deploy the Polish Special Forces because they have a completely different set of interpretations on the law than we do, or they might even have declared war and we haven't. Deploy the Estonians, deploy the Romanians. And whereas you would hold back some of the other nations who have a different interpretation of law, right? And the legad, I assume, is the one that, again, has got to be on top of all those interpretations and apply not just then their national take on it, but a sort of higher level understanding, right?
In an ideal world, we'd all deploy on the same settings and have consistent and coherent views on international law and the same rules of engagement. That would be the ideal multinational deployment. But yeah, you're right. Reality is there's a lot of caveats. A lot of people have red cards. A lot of people have their own national positions on things. A lawyer has to be across what those positions are. The clearest example I can give is in the maritime space, where there is no multinational agreement or arrangement that governs the deployment, but the combined maritime force in the Arabian Gulf, which is still ongoing and has been for some time. All those nations come together on their own interpretation of law of the sea and maritime security regimes. So a legad will have to carefully navigate and unpick all of those limits and permission space as well for all those respective countries.
What I love about this, I saw a great legad operating in Bahrain at JIFMIC, CMF, the Combined Maritime Force, whatever it is, 76 nations or something crazy, right? From around the world, lots of them without actually any maritime forces, but they're there to do some stuff. And one legad had taken the view of, right, we need to establish a common set of principles for everyone, which ended up being the most restrictive set of behaviours across the coalition, which was ridiculous. A new legad came in and went, no, we need to break that completely. And we need to allow and exploit these opportunities that exist for the commander, right? That sort of legad ability to dive in, understand and go, you could use these guys for that. This is an amazing opportunity here.
And I think that's it, right? You have to leverage all of your tools at your disposal to achieve the mission objective. And I think for states to be able to do that, as long as it doesn't sort of breach your own legal obligations, as long as you are not aware or contributing to a fundamental breach of international law, we can definitely, I would say, support a multinational operation that is the widest permission space possible to achieve the objective. But yeah, why would you go for the most restrictive? I don't.
Well, again, it's this view of the law which says it's a boundary rather than the interpretation and enabler to operations and retaining who we are, right? The other point about law, which always gets me, is where commanders go, well, this is ridiculous. We should never have signed up to this. We don't agree with this. It's awful. It's what makes us who we are as a civilization, as a sort of, set of collective people known as the West. This idea, these principles, this is what bounds us as a group with a set of values. And our adherence to international law does that as a military force.
Yeah, but I'm not saying that people should act with impunity or without restraint. Absolutely. I think that sets us apart, as you say. We're a professional armed force. We operate with that set of guidelines and principles. And I think that identifies us as a disciplined and ultimately successful armed force. And I think that goes for coalitions as well. If they can operate within an agreed set of norms, then that is, I guess, the ultimate Because I think there is a school of thought, an interpretation that, where there is a range of options in terms of use of force, at least, you apply the most restrictive, right? That's the legal framework. But then when I was thinking, it's more about if you want to achieve a wider objective, and I'm thinking the maritime space is quite good for this in terms of interdicting a vessel that's suspected of
oil smuggling.
Yeah, something like that, right? And say it's flying a certain flag. Some countries adopt a rule that they do master's consent boarding. So if you get the master's consent, you can board and interdict that vessel. Other nations, such as New Zealand, we don't have that same power.
Flag state permission.
Yes, it's got to be flag state consent, right? As a lot of, I think the
UK does
the same thing.
Yeah.
But can you then leverage your different permission spaces in order to achieve the effect you're wanting, which is to, stop a smuggling operation being conducted?
And the use of the maritime, I think, is really interesting because not many people realise how much of the ocean is ungoverned space.
Oh, yes.
Right, that nothing applies.
I mean, not ungoverned. I mean, the United Nations Convention on the Law of the Sea, which I know as a legal geek is one of my favourite conventions. Again, really quite a lot of countries have signed up to it. It is one of the more supported international law conventions. But as you highlight, the high seas are not the subject of anyone's territorial jurisdiction.
Well, just going to that, territorial jurisdiction, when you're conducting a military operation in someone else's country and you're governed by international law and you're governed by national law and rules of engagement, how much of local law and customs are you bound to adhere to?
So there's a few ways in which a military will be present in the territory of a third state, right? You're invited there.
Yep.
At which time their local laws will generally apply to you and your forces unless you have a specific agreement or arrangement exempting you from those local laws and customs. You go there without their permission, otherwise known as an invasion, at which stage you could potentially be in occupation of that country, and local laws and customs clearly wouldn't apply because you generally bring your own laws with you when you invade. And obviously, United Nations Security Council resolution could also provide a justification for entry into that state. And usually the resolution would either exempt or somehow articulate which local laws would apply or not. Usually there'd be some privileges and immunities for service people in those third countries.
And there is this other point about the declaration of war. Some people have tried to make this excuse that if war's not being declared, then the rules don't apply, which is utter bunkum, right?
That is a complete fallacy that somehow you need a declaration of war for it to be considered an armed conflict or a war. An armed conflict exists on a factual basis. So it's a fact that an armed conflict exists. It's not a statement.
Before we started recording this, you and I have been in contact a while, and we were both sort of giggling at the idea that AI would replace the legad or legal advice. Recently, we've had reports that AI will replace the entire legal profession in various countries, that all lawyers will be out of work within 3 years if Elon Musk has his way, etc., etc. I find it incredible, given everything that we've talked about, that the primacy of interpretation and influence, that people believe that AI has a place in this. What's your feeling about the development and the utility of AI in this space?
I think it's both an amazing opportunity for the legal profession and also deeply worrying in certain circumstances, particularly in the area of operations and armed conflict. But I must admit, I think when we first spoke and I sort of said, no, AI could never replace a human being and a lawyer. And I think I go back to like the first iteration of ChatGPT, right, where it tried to insist that there were only 2 R's in strawberry. And that was basically, it said, I bet you $1 million that there's only 2 R's in strawberry. And I was like, clearly this AI is not going to be replacing proper quality legal advice. Now, I think what we're up to 4.5 or the latest iteration at least, it is deeply impressive what it can do and what it can pull. And so can I see it replacing a lawyer? Not yet, I'm going to say. So I'm not going to be quite as finite as saying never, but I would still like to see that human judgment and that sort of professional ethical obligation still have to remain with the human being. And the accountability, I think, still has to remain with the human being. But I see AI deeply augmenting lawyers and legal advice and replacing a whole lot of back-end legal work as well.
I find it interesting that there's been a bunch of stuff with the latest AI models that are out there at the moment, particularly large language models, where they're continuing to hallucinate in dangerous ways, right? We've had police operations over in Europe go completely wrong because AI has hallucinated evidence. We've had contracts go badly wrong because AI is hallucinated, even research papers, right, where their AI is hallucinating. I mean, frankly, it's just making up the references to prove its own theory. We haven't got behind that bug. Even if you do, though, I go back to where we came into this conversation about the relationships. I'm not sure how much of a relationship one can establish on the basis of not entirely trusting the machine that's giving you advice. Those relationships, I'm not sure, could be replaced.
Who knows, in terms of the future, we might all be talking to robots. But I would agree. I think that human-to-human interaction and being able to bounce ideas off each other as well, there's something intrinsically human and person-to-person rather than person-to-machine, I think, about it. I'm just trying to think, like, could a machine replicate that? Could a machine offer challenges and offer that sort of... I just don't think you can outsource that kind of cognitive reasoning and responsibility, I think, that we would need.
And there's also a sort of face-to-face element. Right? There is a talking to someone in a room who it's not a yes or no answer. There's nuance and understanding behind it. And you can get to explain and know it's based on something, particularly a deep professional knowledge and understanding of the background, rather than a machine that's sort of generic, homogenous, and may well be hallucinating. I mean, there was a great piece on AI recently that said, do not trust and verify anything that comes out of AI, which I thought was a great mantra.
No, I think you have to. I mean, don't get me wrong, the models are getting better and better all the time. And again, it's only as good as the data that you sort of put into it. But I think you still know those critical thinking skills. In fact, I would say that for the military, the lesson learned is that we need to probably ingrain these kinds of skills earlier across all ranks levels, across all corps, because it's not going to go away. It's going to continue to be increasingly embedded in armed forces as a tool, and it's a powerful tool, but you will need to interrogate that tool using the right series of questions and the right type of engagement, because otherwise, yeah, you're right, you could end up with a completely wrong and incorrect answer. And I'm just trying to think of a couple of examples, but...
Misidentifying nodes incorrectly.
Correct.
That are supplying hospitals and schools rather than a military power plant or whatever.
Or even down to individuals, right? So misidentifying, I mean, there's some algorithmic bias based on racial characteristics, and some of the testing I think that they did for law enforcement in the US actually had a really high rate of misidentification. But on the flip side as well, though, you have, I think, in terms of the Turing test, the AI models couldn't be indistinguished from human, like, what is it, over 73% of the time? So that's what we're getting to now, and it's improving all the time. But yeah, you're right, there is a danger with it.
I mean, the other point is, I don't know how many times you've come across this, but AI can't walk into a commander's meeting and go, you're about to do something really silly here. Right? You have to ask it for advice, and maybe it could chirp up, but can be silenced. A person walking into a meeting can't be silenced.
That's right, and it's that speaking truth to power and being able to have the free and frank conversations with the command chain. And AI, I don't believe, could ever replicate that. I mean, commanders may want it potentially because it doesn't do that.
Yeah.
But I think you need that friction.
I mean, that's the real danger, is commanders want it. In the same way that people have talked about course of action development. Commanders want it because it gives them black and white options.
I also think it's dangerous as well because we all like people to agree with us and agree with our point of view. And I think commanders need to be aware and attuned to the fact that if everyone's agreeing with you in the room, including your AI bot, then there's an issue here. And I know that we do red teaming and things like that. I know the AI can do that as well now, but I think for commanders, you need that friction in your decision making, because otherwise I think then we're into a dangerous groupthink scenario where that's when poor decisions are made, that's when poor targeting calls have been made, and mistakes end up with catastrophic results.
So we're running out of time, and I know your time is absolutely jammed, but I wanted to get to this question, which I hope is not too unfair. I guess during the post-Cold War period, we saw an evolution in expectations on military force and their behaviours. We saw things like anti-personnel mines moving into the capabilities that were not considered viable by a number of nations. Moving back to an era of great power competition, where do you see international law, humanitarian law, where are these things likely to move? Have you any sense over predictability of stuff?
Some people have argued that international law is sort of in its swan song, fading light, but I think it still remains the plank of who we are as a civilization and society. It behoves us all, I think, to ensure that we support and cherish the rules-based system that we have. It's been the foundation since the war. And I take hope, actually, from the Geneva Convention and particularly the additional protocols. They were drafted just after the Vietnam War in an era of deep Cold War situation. And yet still, a large number of countries came together and were able to agree some pretty fundamental rules that govern the armed forces and their behaviours. So I do have hope that despite, I think the Canadian Prime Minister was talking about this fracturing, I think, of the rules-based system, I still have hope that we all want a peaceful and prosperous world, and the system that underpins that, I think, is fundamental to ensuring that we can all do that. There's optimism, I think, at least for the future.
Well, that's helpful, but you do, the other side of the coin, and other people talked about, is the potential for it to go the other way, where states undo a lot of the expectational behaviours and walk back. As it stands, that still wouldn't exempt them from prosecution.
I'd like to think that the world would come together, much as they did post-Yugoslavia, much as they did post issues in Cambodia, and would hold both states and individuals to account. You cannot contract out of accountability for ethical and lawful behaviours, no matter what your rhetoric may say.
And I think that's really important to point out, is lots of people think about war crimes and they go back to sort of Nuremberg. But, there have been instances since then where war crimes have been successfully conducted and prosecuted, right?
Absolutely. And I think there are arguments that it takes a long time, and there are arguments that not everyone faces justice. The system is not perfect, and I'm no way meaning that this is a perfect system, but is the system we have is important to uphold it. Yeah, the ICTY, classic example of the world powers coming together and prosecuting war crimes. And now we have, obviously, the International Criminal Court, which the UK and New Zealand have both signed up to in terms of the Rome Statute, which again provides a framework for accountability.
Lisa, it's a sort of a hopeful look at the future. Thanks very much for your time. Been great.
Thank you.
And that's where we left it. I was really struck by the importance of personality in a discussion between the Legad and the commander. Maybe some people think that AI, large language models, as they get better, will replace this, but I'm not so confident. There was clearly more to discuss, but in retrospect, one of the things I should have asked about was whether, for the New Zealand Defence Force specifically, they tried to match Legad's two commanders to take account of this personality causation. Maybe we'll come back to that at some stage in the future. The show is sponsored by Systematic.
Citaware is trusted by more than 50 nations worldwide, including 18 NATO nations, and is the world leader in command and control software.
We hope you enjoyed the show, as well as telling your friends and colleagues about it. Please do hit the like or subscribe button. The episode is produced by AureliusThinking.com as a show for the Waiver Room, the home of intellectual curiosity and challenging thinking for military professionals everywhere. Thanks for listening.